Hearing from Dan Kautz. And Dan Kautz is a registered investment representative with investment experience since 1999. Building and maintaining client relationships is Dan's top priority. Due to personal life experience, Dan focuses a portion of his practice on funding and managing supplemental needs trusts and works closely with others in the field. So saying that, this is what our topic is today of supplemental needs trusts. I'm going to turn it over to Dan right now. Thank you for joining us today, Dan.
Great, thank you, Kelly. Thank you for inviting me to be part of the panel with SOF. It's very important we get this information and these words out to fellow family members. I remember if someone didn't tell me the information I'm going to share with you today, our family would have been in dire straits when my parents passed. And as Kelly alluded to, I'm the trustee and the guardian and brother and sister. Two, my older brother and my older sister are disabled since birth. And that's how I really got into this. This is the passion that we have for it and why we do what we do. So today what we're going to talk about is an overview of supplemental needs trusts. And I want to be really clear and very clear that I'm in Buffalo, New York. And the laws and regulations on supplemental needs trusts can go all the way down to the specific county that you live in. Like I know here, we have to get county approval for our supplemental needs trusts. So every state, every county is going to be different. So the information I'm going to share with you today is a very high level information. It's a lot of vocabulary and information that's very powerful and can be used. But I really would want people to seek out local professionals to execute any kind of supplemental needs trust and to build that document. In other words, the lawyers that build the documents. So with that said, what I'd like to do is just move to the next slide here. And why would you use a supplemental needs trust? And here's where some of the vocabulary is going to start. The biggest reason we use a supplemental needs trust is to make sure that our children get public benefits. I know in our house, in our family, we rely on Medicaid a lot. Now, it's a federal level entitlement program, but then the money's pushed to the state, and in some states, it's pushed to the counties. That's why you've got to get very specific rules when you build a supplemental needs trust. So let's first talk about SSI and Medicaid. SSI, supplemental Social Security income, and Medicaid are entitlement programs. You have to be below a certain threshold of income and assets in order to get those programs. And SSI, that's going to be a couple bucks coming into the house, depending on the state and county you're in. It will have different levels of how much money you can get from SSI. But really what we go for is the Medicaid. As in many of the houses that I'm talking to today and people that are here, it's the wheelchairs, the food, the pumps, the medications, the doctor's appointments, the vans, all of that stuff is Medicaid dollars. The build outs of the houses and the bathrooms and everything like that, and the tracks and the ceiling, Hoyer lifts, all that stuff is Medicaid dollars. So we want to make sure that our children or our brothers and sisters, our family members are eligible to get those services. Again, nursing. My brother and sister are at a group home. So the group homes, those are all things paid by Medicaid. SSI and Medicaid are entitlement programs. These are something that these are entitlements that people will receive that are below a certain income level, but also if your child is 18 years old, they can file for their SSI on their own. Some may be on a waiver program, and it will depend on your waiver programs. But you got to look into that at a very specific level. But at 18, your child should be able to apply for SSI and Medicaid. And in our area, $1 of SSI gets you the full boat of Medicaid. So what will happen is parents will start the process of applying for SSI, and they're going to get a letter back that says you're over-resourced. Unfortunately, that's a vocabulary word I didn't put in here, but if you get a letter that says I'm over-resourced, that means the child has money in their Social Security number. Well, my child can't work. How could they have money in their Social Security number? Most common things we find is grandma and grandpa bought bonds, U.S. savings bonds, and they're in the child's Social Security number. The Gerber policies that you might have gotten your child at birth that had no medical requirements has cash value in it. That cash value could be more than the $2,000 threshold. It's another thing, $2,000 threshold. Anything over $2,000, you start losing your SSI. So it's easy to find bonds, to find the Gerber policies that have those life insurance policies that have cash value in them. The other thing you want to look for is an investment that is titled UTMA, Uniform Transfer to Minors Act, or UGMA, Uniform Gift to Minors Act. Transfer at 21, gift at 18. What did I just mean by that? What happens is you might go to the bank or go to an investment advisor and say, I'd like to set money up for my child who's a minor. And they'll say, fine, you're going to put the money in, but what we'll do is we'll put it under the gifter's, like my social security number if I was doing it for my brother and sister. But if the account is titled UGMA, when my brother and sister turned 18, that money became theirs and it went on their social security number. Or UTMA, when they turned 21, that money went on their social security number. So we're into the first slide with the first bullet point, and I've given you a bunch of vocabulary. The biggest thing I want you to pull from this is when your child's 18, you're going to apply for SSI in order to get Medicaid. And that may differ because of waiver programs. But when you do that, you fill out the forms, you go through that whole exercise, and you might get a letter back and you're over-resourced. If you're over-resourced, check the culprits. Bonds, UTMA, UGMA, life insurance, like a Gerber policy, has cash value in it. When you're over-resourced, what do? How do we get the child on Medicaid or SSI? Why does Supplemental Needs Trust come into play? This is when we reach into the child's pockets, quote unquote, right? We go in and we get that money and we transfer it from their social security number into a supplemental needs trust that has a different tax identification number, referred to as an EIN, ironically, employee identification number. And then when that money leaves the child's social security number and goes into the trust that has an EIN, because that trust is very specific of being a supplemental needs trust, that is unattained assets, the child can no longer have access to that money because they don't have ownership of it. Boom, problem solved. You're not over-resourced. We're going to go farther into what type of trust and a little more roadblocks you might hit, but that's the concept. So if you're applying for SSI, you get the letter of over-resourced, you got to think of a supplemental needs trust. That's one route to go. Underneath on a bullet point, I wrote, what is a DAC, D-A-C, a disabled adult child? This is a child who's receiving SSI and through no fault of their own, end up getting another source of income. What are you talking about? If mom and dad retire, become disabled, or die, those three things, all of a sudden that child ends up getting an income source that it wasn't through their efforts, through no fault of their own. What happens when mom and dad retire? Mom and dad will then click into their social security. Mom and dad will start receiving social security, but if you have a child that's permanently disabled, that will be identified when you apply for social security, we hope. Check into that, make sure it does happen. Hi, my name's Dan, I'm retiring, I want to click on my social security, and by the way, I have a child who's disabled, and here's their social security number. Oh, Dan, that child now is eligible for a portion of your social security. So all of a sudden, that child may have more income than they're entitled to, and they could lose their SSI or Medicaid. The other way is if mom and dad become disabled or die, because then the Social Security Administration will pay Social Security disability to mom and dad, which the child who is disabled is entitled to some of that money. Or when they die, that child who's disabled is entitled to that money also. So what will happen is, well, what we'll say is the child gets in a pickle. In other words, through no fault of their own, suddenly they can't get the resources they want to get or they need, the SSI and Medicaid. And the reason why I use the word pickle is because there's an amendment out there under the Social Security Act, I believe. It was written by Senator Pickle, not sure what state, where it came from, but that was his last name. It's called the Pickle Amendment. And what happens is if the child ends up receiving income through no fault of their own, through those sources, because mom and dad retired, became disabled, or died, and they are over-resourced, at that point, they're considered a disabled adult child, a DAC, and they can still receive SSI, but they also might receive SSI and SSD. So you could have two checks coming in at that time. So SSI and Medicaid entitlement program. The other two is SSD and Medicare. We aid the people that need aid. We care for our pensioners. That's how I remember it. So when a child becomes 18 or older, mom and dad retire, die, disabled, they'll switch to a DAC. And at that time, they are eligible for SSI and Medicaid, but also SSD and Medicare. Families may receive both or all four of those sources. They may receive one or the other. This is where you have to get in touch with a local attorney that knows these rules, somebody who's versed in supplemental needs trust and disability law. So those are the two things I want to talk about right off the bat, and why you'd use a supplemental needs trust, because you want to make sure that you get that SSI and that Medicaid, because it's very important to the houses. The child will be over-resourced. You're able then to move that money to an SNT, a supplemental needs trust. The other thing you might use a supplemental needs trust is when they have a lawsuit settlement possibly, or an inheritance from aunt and uncle or mom and dad or whoever might have given them inheritance. You can pass an unlimited amount of assets for the benefit of the person with disabilities. A trust is not limited to how much money it can own or property. It can own stocks, bonds, real estate, annuities, life insurances, all kinds of things, bank accounts, right? It can own all those types of assets, as long as everything is titled properly. So this is a tool that you can use to move money from one generation to another. And sometimes, in most cases, this is a lawsuit situation too, that if the child is a plaintiff, they win, the money technically is theirs, but it doesn't go into their pockets. At that time, hopefully the defense lawyer or your lawyer will know to contact an attorney that knows how to set up supplemental needs trusts, get a court order to move the money to the trust. And then the child doesn't become over-resourced, and they can still get Medicaid while they are still sitting on a trust that might be worth millions of dollars, or an inheritance that might have hundreds of thousands or millions of dollars. The other thing is a trust will protect the money from creditors. We've had numerous accounts or numerous situations where we had a child that was highly functioning but disabled, and they'd get into credit card debt, or they'd sign a contract that they had monetary responsibility for, and they try to come after that child, and usually that it won't work. So they start looking around and they find out, oh, they got a trust, but trusts are protected from creditors. So the money can't be moved out or gotten by creditors in case that child makes a bad financial decision. More importantly, it's a good estate planning tool. In our family, my mom and dad, I'm the youngest of six, my mom and dad said, hey, Dan, you want to look out for your brother and sister. We're going to give you a little extra money. Okay, I'll do whatever you want me to do. So if they gave me that extra money and it was in my name, what happens if I get married and then divorced, or if I get in a car accident and sued? Is that money up for equitable distribution or goes towards that lawsuit? The answer is yes. But if my mom and dad would have said, Dan, which they did, we're building a supplemental needs trust for your brother and sister. We're going to make you the trustee, and we're going to put the money into the trust. So that way, if my life unfolds, if I make a bad business decision, if I go bankrupt, if I have creditors coming after me, if I get divorced or in a car accident, that money is protected. It can't be taken away. That money's there, still there for the benefit of my brother and sister, but I'm just the trustee, but it's not my money. So it's a great estate planning tool. So just recapping, public benefits. If you're over-resourced, that's when you think about a supplemental needs trust. If you're somebody who's getting near that retirement age to collect Social Security, or there's been a disability or death of mom and dad in the family, this is where you have to be familiar with the term DAC, disabled adult child. Then we can pass on money or assets, all types of different assets for the benefit of the disabled child, and via a trust, and it protects it from creditors, and the example of a good estate planning tool. just in case life unfolds for the person that you want to entrust the money with to take care of your sibling or your son and daughter, that it's protected in case they get into trouble. Moving on to who's involved in the Supplemental Needs Trust. Who's who? Who does what? The first thing is the grantor. This is the person that actually gives the money to the trust. In a trust document, it's usually in the first paragraph, Susan Smith's the grantor on behalf of their child. Susan Smith, the mom, is giving money to the trust on behalf or for the benefit of that child. All right, they're the people who give the money. The beneficiary of the trust is generally the child with disabilities. They're the ones who are going to benefit for that trust being in place. How do they benefit? The assets are not in their name, therefore they can get public entitlements. Or if the public entitlements doesn't meet what they need, we can go out and add to those. In other words, we might add a nursing shift, we might add extra slings or Hoyer lift slings, or an extra wheelchair or shower chair that's more comfortable, something that Medicaid may not pay for, or maybe some entertainment or something of that nature. This is what the trust could be used for. The trustee is the person who's in charge of filing the taxes for the trust, making investment decisions, working with professionals such as myself, the investment advisor, the attorney, or other trustees that may be involved, or the courts or social services or whoever may also be involved. The trustee is a very important position. Sometimes we have families that will look around and they're like, well, you know, my other son who's not disabled, I don't know if he's really good with money, but I know my daughter who's not disabled is. So I'm going to make my daughter the trustee. I'm going to make my son the guardian because the son might know more of the needs and wants of his brother. So those jobs, you want to think about who does what. The trustee, in my opinion, is not as important as the guardian, which we're not even talking about today. Maybe in another session that they have about guardianship, you can talk about that. But the trustee is the person that really meets with me, meets with the professionals, makes sure the taxes are done. Their signature carries the day. In a lot of our areas, you're going to have to report the trust's holdings or get the trust certified either by a court order or by social services or the Social Security Administration. This, again, is what you need to do is talk to a local practitioner, somebody who really knows supplemental needs trusts, be it the attorney is probably the first stop, and a financial advisor like ourselves that has knowledge in trusts and trust investing. Because an example of how we would get involved is sometimes these trusts will get audited by the county social services or Social Security, and they're going to need all the statements for the last 12 or 15 months or whatever it is. And we're able to pull all that together and help them through the audit. So these are the people that they're the cornerstone of building a trust. So when you feel you need one or you come up with the time that you need one, I really think anybody with a child with disabilities needs a supplemental needs trust. They need it. It's not a choice. Seek out a professional in your area, such as the attorney first, and then you can go over with this vocabulary and identify who's the grantor, the beneficiary, the trustee, and how are the courts involved. It does get a little more interesting if you are in a family with a divorce and everything like that, but that again is where you want to seek out a local professional. Right here is, I think, one of the most important pages. This is identifying where does the money come from. I'm going to talk about 4 different supplemental needs trusts. These are all trusts. They're all supplemental needs trusts, but they have some different rules. And it all depends on how they get funded. In other words, where did the money come from? Let's start with the top left, which is called a testamentary supplemental needs trust. This is where you see an attorney, and they're going to talk to you about what a supplemental needs trust is. And you're going to say, maybe at this time we don't have a lot of assets to move around. And really, I just need something that's there when my husband and I die, my spouse and I die. So the lawyer may say, listen, let's draw up a will. And in that will, I'm going to put a few paragraphs or maybe 5 or 6 paragraphs. And they're going to be asleep inside your will. And when you die, they wake up. And when they wake up, that's when the trust is actually up functioning and can receive assets. A testamentary trust is a trust which is of words or paragraphs in your will that cannot receive money while you're alive. While you're alive, you can't fund this. This can only be funded after the death of the person's will, after the death, because then the person's will get probated and opens the trust. Good and bad things about this. Good, less expensive. The other thing is we may not have assets right now that we can fund a trust with. So why should I go through the expense of building a bigger one and all the legal hassle that I might have to do? The bad side is that when it opens up, is the law has to follow. In other words, if you were to build what's called an inter vivos trust, a living trust now, which is all the other three types of trusts, they follow current laws, the laws of today. A testamentary trust will follow the laws of tomorrow. Upon your death, when it opens up, are the laws it has to follow. Good or bad? At least you know now what you're dealing with if you open up the trust now. If you do a testamentary trust, some laws may change, some rules may change, the trust may be adequate, may not be adequate. I have never ran into a situation where it was an inadequate trust. Never, not yet. And I hope I don't, but it may be a possibility. This is where you talk to an attorney and find out what would be the best route for you. When a testamentary trust wakes up, it actually starts functioning like the trust that's on the bottom left-hand side, called a third-party supplemental needs trust. Why do we like a third-party supplemental needs trust? The biggest thing is it's funded with anyone's money other than the child with disabilities. This could be the pizza boy, the babysitter, mom, dad, grandma, grandpa, anybody other than the child's money. In other words, it cannot come from the child's social security number. So a third-party trust will be open today, follow today's rules. All those players that I mentioned before will be involved, right? You're going to name a trustee, which generally would be mom and dad. Then you can name a successor trustee, which might be a sibling or an aunt and uncle, but you like to name a successor trustee that is a contemporary of the child with disabilities. You don't want to name mom and dad's brother and sister or the uncle, because when mom and dad are 80, how old's the uncle, right? So you want to make sure you jump down a generation. That's usually a good idea. Third-party trust, built today, alive, can be funded today. The money that goes into a third-party trust can be put in by anybody except the person with disabilities. In other words, how do you identify that? It cannot come from an account that has a child with disabilities, their social security number on it. It has to come from mom and dad's account. It has to come from some other source. Okay? Third party, the types of trusts that are on the left side here, testamentary and third party, if you look, protected from a Medicaid lien. What happens is when somebody has a supplemental needs trust and they're receiving benefits, Medicaid or SSI entitlement benefits, there's a lien that's put against them. I jokingly say that your local Medicaid office has a clipboard on the wall with the child's name on it, and every day they take that clipboard and they add how much money they spent on that child via Medicaid. And when the child dies, they're going to take that clipboard and they're going to add up all those dollars, and they're going to come to you and say, I'm sorry, I heard that Johnny passed away, but we know you have a supplemental needs trust. And they also probably know the balance. And they're going to say, well, you have a Medicaid lien of $2 million. And I see the trust has $300,000 in it. Well, if it's a testamentary or a third-party trust, Medicaid cannot claim against that money. They can't tell you to give us that money. That money that's left in those trusts after the death of our disabled child, Johnny in my example, goes back to a charity or to an individual. It does not go back to Medicaid. This is why we like private family money to go into a third-party trust. It makes sense. So, recapping, left side of this slide, testamentary, paragraphs inside your will, you cannot fund it today. It will only wake up upon your death, the death of when the will gets probated from, mom and dad dying, okay? Then it opens up, then it can receive assets. A third-party trust is open today. It follows today's rules. It can be funded today with $5, $2, whatever. And it can just sit there and wait until an event happens. An event, mom and dad die, grandma and grandpa want to leave money to their disabled son, Johnny, leave it to that type of trust, third party. And when Johnny, our child with disability, passes, Medicaid has no right to reclaim against that money. It's that might be the Medicaid lien. Moving to the other side, which is a first party trust. Why do we call it a first party trust? Because this party is funded with money from the child with disability. So let's say that a child receives receives a lawsuit settlement. That technically is their money and their social security number. We have to reach into their pockets and we must put it into a first party trust. We cannot put it into a third. The only money that should be funding a first party trust is money that comes from a child with disabilities social security number. These trusts get funded by mistake or generally by lawsuit. Let's identify the mistake because this is the one that gets me. If, let's say you are at your employer and your employer puts into a new 401k and you go down and see a guy like me that sits across the table from you and says, hey, when you pass away, who do you want to get this money? Well, I want my spouse, my wife to get the money. Okay, spouse, primary beneficiary. But if my spouse predeceases me, who do you want to get this money? I don't know, I guess my children. Okay, so you either name your son, Johnny, again, with disabilities by name, or you mark a box that says children equal shares. Life unfolds. My wife predeceases me, I die, my 401k can't go to my wife, she's already passed away. So then they look at it and say, oh, children equal shares. So I have a son, Michael, and a son, Johnny. My son, Michael's not disabled, my son, Johnny is. They get 50-50. Well, we already built the third-party trust. That money should have gone to the third-party trust. You didn't fill out the beneficiary designation correctly. You marked children in equal shares. And in that way, when you wanted the money to go to either a testamentary or third-party trust, that trust is waiting. Because you didn't make those trusts the beneficiary, you named your children in equal shares, the money flies over the trust, splashes in Johnny's pockets, and now Michael will have to reach in and get the money out, but he has no choice but to put it into a first-party trust. So that's how those get mistakenly made, and I can't tell you how many times that happens. In our office, we are sticklers for beneficiary designations. In the next slide, I'm going to show you what assets you should pull aside and realize, what are my beneficiaries in here, right? So how does the first party trust get funded? Lawsuit or by mistake? By mistake, it can be stopped if you just understood how to fill out the beneficiary designation forms. A primary beneficiary is usually husband and wife. A contingent beneficiary is usually the kids. That means contingent. That means the primary has died before you have. Contingent beneficiary says, okay, primary's died, where does it go? A lot of people just mark that box, children equal shares. Stop. Take the time to read that. And if you have a testamentary or a third-party trust set up, consult with your financial advisor, consult with your lawyer to understand how you fill that out. I leave it to the trust in the name of, and then each one, well, the third-party trust will have an EIN, right? It will have its own tax identification number. The testamentary trust will not. It will just say, I leave it to the testamentary trust, but please visit with your lawyer, with a financial planner who knows how to do this stuff. Make sure it's correct. Contingent beneficiaries. Whenever you have somebody like me sitting across the table and saying, when you die, who do you want to get this asset? Stop. Take the form and say, I have to visit with my attorney or my advisor, and they'll fill that out. First party trusts get funded by mistake or lawsuits, but the big thing here too is that the death of Johnny, unlike the other two, Medicaid has a right to the money that's left there. We had an example, we had a large lawsuit settlement, took care of the child passes away. Medicaid sent us a letter saying, hey, you have a lien of, it was like in the hundreds of thousands of dollars. We just turned around, wrote a check out to Medicaid for 100 and some thousand. There was still more than $1 million to pass on to the family. That worked out okay. What happens when you have a first party trust and maybe it only has $100 left in it when Johnny dies? Medicaid pulls that clipboard off the wall and says, gee, Johnny has a Medicaid lien of $2 million. They come and say, well, you're going to pay this? I see you have a first party trust. And you're going to say, well, whatever's in the trust is yours. So they turn around, they take that $100 and nothing moves on to the family. But also Medicaid has no recourse to go any further than that. First party trust. The money that's left over in first party trust at the death of the beneficiary, Medicaid has the right to claim up to the Medicaid lien. Again, visit with your local attorney and planner to make sure you understand this. Laws will change state to state, county to county. On first party trusts are absolutely going to be up for grabs at the death of Johnny, but how they reclaim the money and everything is going to be a state by state, county by county. All three of the trusts I just mentioned, testamentary, third party, first party, require a trustee. Generally, you're going to find it to be mom and dad or a brother and sister. Sometimes it will be a corporate trustee. Some documents are written that you must have a corporate trustee. Some you're going to find, I don't have anyone to act as trustee. My brother, my sister, there's nobody in the family that can act as a trustee. We have no one left. Well, at that time, you can use a corporate trustee, but generally a corporate trustee is going to want to have a substantial amount in the trust. Well, I'm a modest family. We don't have a lot in the trust. Now I'm caught. Where do I go? Well, you could go to what's called a pooled trust. Pooled trusts generally break up into two separate. They'll act just like a first party, and they'll act like almost like a third. So what will happen is you'll go to a pooled trust. It's a supplemental needs trust that is the benefit of multiple people, a pool of people that are disabled. And what will happen is they're going to say, where'd the money come from? Well, it came from Johnny's pockets. Well, then it has to go to the first party pooled trust. The pool, the organization, which is generally a non-for-profit, will act as the trustee. They'll have a board of people that are the trustee, and they'll oversee the trust. And whenever you need money out of it, you have to write a letter to them and say, Johnny needs this, Johnny needs that, and they'll approve it or deny it and get the money out to pay for whatever Johnny needs. At the death of Johnny, if it's because the money came from him, Medicaid gets a first right to reclaim their lien, just like a first party trust. So in that case, the pooled trust, the non-for-profit that's running the pooled trust, just took place. They acted as a trustee for you, and you didn't have to have a lot of money. The other type of pooled trust is going to be almost like a third party. Same deal. Someone comes in and says, listen, we have no one to act as trustee, but we don't have enough money to bring a corporate trustee in. So can we act as a pooled trust? Can you act as the trustee for me if I give you the money to go into your pooled trust? Well, I guess we will. So you put that money into the pooled trust. The money did not come from Johnny's social security number. Okay, it came from other sources. The money goes into the pooled trust. The trust board committee will oversee the investments, the distributions of that trust and everything. Again, for a pool of people. But when Johnny dies, unlike a third party trust where money goes back to the family or to charity, the organization, the pooled trust organization, gets to keep the money. You might go, well, that's okay with me because we wanted to make a donation anyhow to this charity, or there's no one else left in the family to get the money, so why doesn't it go to help out other people that may be in the same boat? Testamentary third party, in my opinion, best types of trusts to use. When it really comes down to it, third party is the best type to use. A testamentary trust, it's not alive today. You can't work with it. I'd rather have something that's alive today that we know who's who's the trustee, who's the successor trustee, who's the grantor. Do we have $100 already in a bank account or investment account that's owned by the trust? Yes, great. Then it just might sit there and be the receiver of the money you want to leave to your son who's disabled, Johnny. Instead of leaving it to Johnny directly, you leave it to the third party trust. That's the best planning you could do because the money, you filled out the contingent beneficiary. The money doesn't go into Johnny's pockets. It goes directly to the third party trust. The trustee then takes care of distributions and administration of the trust. And at the death of Johnny, the money stays in the family. The first party trust, best way to think about this lawsuit, yeah, okay, it goes in there, but Aunt Ruth, California, wants to help out her nephew is disabled in Buffalo, and leaves the AT&T stock and puts Johnny's name in there. When I die, I want Johnny to get it. Incorrect, Aunt Ruth. Please put the name of the trust. And then that means that Johnny will never be over-resourced. The money goes into the third-party trust. But if she doesn't and leaves Johnny's name directly, the money splashes in his pockets, and then it has to go into a first-party trust. And then what happens to private family money? It's up for grabs when Johnny passes away. Knowing the difference, it's very important. Knowing where the money comes from. What social security number was attached to the money before it went into the trust. It's everything. This slide is always the one people make the most notes on. Please contact a local advisor and a local attorney because these are going to be very specific. There's definitely federal laws, which I've covered, that are blanket over all states, but then each state and each county can have their own little twist on it. So please seek out local advice and a local lawyer and a local advisor who's knowledgeable in disability law, elder law. Those are the people you want to talk to. I only got one more slide. You heard my alarm go off, and we'll open up for questions. This slide's pretty important. It's the understanding of non-probate probate. We love non-probate assets. We love non-probate assets. A non-probate asset is an asset when a guy like me sits across the table from you and says the following: when you die, who would you like to get this money? They'll include things like life insurance policies, retirement accounts, IRAs, 401ks, TSAs, tax sheltered annuities, Roths, annuities, and some pensions. Joint accounts, which we refer to as joint ownership with the rights of survivor. Other states will have common law situations. Education 529 and Coverdale plans. All of these have beneficiary designations. There's that UTMA, and UGMA. Those are what I talked about at the beginning of this of the presentation. Real property, you can use what's called a deed transfer to move money outside of your will. Probate are things that you have to go through a court proceeding in order to change ownership. This would be stuff like generally real estate, unless you make arrangements through a deed transfer, or anything that's left to the estate. A big mistake is that if you take a non-probate asset, and when a guy like me says, who do you want to leave it to? And you say, oh, my lawyer told me to leave it to the estate, so I'm going to write the word estate in there. What happens is you just took a non-probate asset and jumped the fence and made it a probate. What's the difference, Dan? Why do we love non-probate assets? Non-probate assets move within about 7 to 10 business days after getting a death certificate directly to who you name it to go to. A probate asset will have to stay in a probate account in New York, in this area. I think it's 9 months. And it takes a court action to move the ownership from the decedent or the estate to the beneficiary. And also, anything that's held in an estate is subject to be collected by creditors, Medicaid liens, stuff like that. Let's give you a quick example. Mom and dad own a house. Dad passed away. Mom owns the house, but still owned jointly. Well, dad's passed away. Now she owns it. She goes in a nursing home. She's there for 6 months. She goes there and she gets Medicaid services because we don't have a lot of money. We have to use Medicaid to pay for the housing, to pay for the nursing home. Mom dies. The house then goes into an estate because no one changed the ownership. It was mom and dad, and the last one died. So the house is sitting in the estate. Who's the first person that's going to be knocking on the door to take money out of that house? It's going to be Medicaid. They have right because they paid for your mom's care in the nursing home. They knock on the door and say, well, we're going to put a Medicaid lien against the house. So when you sell that house, whatever the proceeds are, go back to Medicaid to satisfy the lien. Anything over that can go back to the family. But this is the story. Medicaid took my house, or the nursing home took my house. That's because it was left in the estate account. Think about if you have a disabled child and you did that thing with your 401k. Well, I'm going to leave it to my estate. You had every opportunity to put the name of the trust that you built in there, but instead you left it to the estate. The 401k jumped from non-probate to probate. It sits there for 9 months or so. And now there's creditors that can come and take that money. Well, that money was supposed to go to the Supplemental Needs Trust for my brother Johnny. He didn't get any of the money. Well, it's just because you didn't fill out the beneficiary designation correctly. Beneficiary designations are everything. So this sheet tells you these are the things that I'd like you to take a look at home. Make a list. Do I have any of these? And if I do, I better call my financial planner or my lawyer and find out who's the beneficiary and how does it work. Non-probate. This means you can list the name of a person, a trust, or a charity to receive your money. And it will happen in 7 days, and creditors cannot claim the money before it moves. If it goes into probate, it will. It just dawned on me, some people out there might be scratching their head and going, what's probate? This may be a New York thing, okay? Contact your local attorney and your local planner to see if, I know probate's going to be out there, but they call it many different things in different states. I'd like you to figure out, what do you have? Do you have an IRA? Do you have a 401k? Do you have any of these things? And if you do, pull them out, find out who the beneficiaries are. This is the last slide, but I do want to add one other thing. There's a couple sayings I use when I work with the attorneys that I work with on this. Number one, attorneys date their clients, we marry them. And what I mean by that is you see the attorney, they're going to put the paperwork together, they're going to charge you for the paperwork, and that's probably the extent of your relationship until something happens or a review needs to be done. You should take that paperwork and go and see your financial planner, and they're the ones that are going to help you out with the beneficiary designation and how things are invested and what assets should move where. And we make clients. I mean, we've been in the business for over 20 years. I have clients that have been with me still from day one. We marry our clients. They stay with us. So you want to make sure that you got the documents set. Then you want to make sure you got the right assets going into the right document. And that's the beneficiary designation. The other thing I say is this: you have to have a car before you can put gas in it. You have to have a trust before you can name it a beneficiary. Don't run out and name some fictitious trust as a beneficiary. You have to have the document first. That document has to be in hand before you can name it as a beneficiary. Got to get a car before you put gas in it. Okay? At that time, just want to open up for a few questions. I see there's a few. And again, I want to be very clear that I might have to just say you're going to have to get local counsel or seek your local a local person in this area that can help you. Go ahead.
Oops, just lost my screen. Okay.
Kelly, I can't hear you.
Our first question says, at what age would you say a special needs trust should be started?
Immediately. It doesn't matter on the age. You want the supplemental needs trust to be created because you never know what happens to mom and dad. Who does that bell toll for? You want to have the supplemental needs trust created immediately, but you also want to keep your head up at age 18 to file for your SSI and Medicaid. So there is no age limit. Get the supplemental needs trust set up right away.
Our next question is this type of trust the same as trusts that are usually mentioned with wills?
Seek your local advisement, your local lawyer, but supplemental needs trusts are very specific. They have a very specific wording. There's many different trusts that can be put inside of wills. There's trust for minors, supplemental needs trusts, grantors trusts, all those generation skipping trusts. So the answer to that, no. Contact your attorney, get specific. I want a supplemental needs trust and prove to me that this is a supplemental needs trust. And then they'll pull out the language and there is a code that identifies it to make it a supplemental needs trust.
Our next question is, how exactly does money within the trust get spent? Can it be used in real time like a bank account for expenses and not affect Medicaid?
That is correct. That's a great question. Money should never be given, cash should never be given directly to the beneficiary. Okay. You don't want to say, hey, Johnny, here's 40 bucks, go and pay for clothes or something like that. Okay. The trust wants to pay for goods and services directly. They don't want to give the money to Johnny for him to go and get it. That's number one. Number two, a supplemental needs trust should only be used for everything but food and shelter. That's what SSI money is. That's what mom and dad are supposed to support. So supplemental needs trust should not pay for food and shelter. If it does, it just decreases how much SSI money they get. How does it get invested and how do you get to it? What we'll do is take a look at the asset that's coming in, if it's cash, if it's bonds, mutual funds, stocks, whatever, and what is the need for the child? Do we have daily needs or do we really have far out needs when mom and dad pass away? Once we identify the needs, we follow what's called the Prudent Man Act. You invest for the benefit of the beneficiary. And yes, we do have checking accounts in here, bank accounts in here. We have ETFs set up to pay for cell phones, to pay for cable, all kinds of things. So it can be used for day to day. It just identify what assets doing what asset is invested and how it's invested and what is it supposed to do. And work closely with your financial advisor to make sure that it works correctly. The mechanics are in there. Okay. I hope that answers that question.
And I feel like this might be a similar question. You may have just answered this. Are there rules about what the money can be spent on?
Everything but food. A supplemental needs trust will have wording in there. It says this trust is built. I'm paraphrasing. Okay. This trust is here for the benefit of the beneficiary to make sure that they get all government entitlements first, and then it can supplement those entitlements. That's why it's supplemental needs trust. So the rule is anything but food and shelter. And that's something that gets, depending on the type of trust, a first party trust generally gets audited at the end of every year. Third party trust, maybe not. Pool trust gets audited every year. So they're going to see, and social services, Social Security Administration, people that are giving you the entitlements, they're going to see what that money's spent on. So you got to be careful. It's not something like, oh, they'll never find out. They will. Okay. So back to the question. What can be spent on? Anything but food and shelter, as long as it's for the benefit of the child.
Our next question is, how does this compare to an ABLE account?
Oh, I was hoping that we wouldn't get this one, but that gets into a whole nother conversation. I'll tell you the big differences. An ABLE account can pay for food and shelter. An ABLE account will act like a first party trust. Any money left in the ABLE account at the death of the beneficiary, Medicaid can get a hold of. And here's the hold up. We don't do ABLE accounts, and this is why. Who's going to sign the application? Is it mom and dad, or is it child with disabilities? Well, if it's mom and dad, because the child with disabilities doesn't have the capability to do it. Well, in New York State, do you need a guardianship to move the money? That's a fight we're having right now. So it gets a little complicated on the ABLE accounts. But how does it differ? The big thing is it can pay for food and shelter. An example of how we're using our ABLE accounts are following. We have children a friend of mine who is a lawyer that I work with a lot, who's a trustee over many of our trusts. We have children down in the city of New York, and we can't afford, their SSI doesn't cover their rent. So what we did is we took money out of a trust, put it into an ABLE account. And then what happens is when their SSI money comes in, we supplement whatever their rent is out of the ABLE account. By doing that, we don't diminish their SSI check. Think about it. Because if their SSI check's coming in and we had to take money out of a trust to pay for the housing, that's in-kind support and maintenance. And what happens is it brings down their SSI check. So if we just took the money from the trust, put it in the ABLE account, let the SSI come in to pay the rent, then we use the money from the ABLE account, their SSI is the most that they can get. That's an example of how we're using ABLE accounts. How does it differ? As I told you, ABLE accounts can pay for food and shelter, supplemental needs can't. And then it gets a little more specific on who's signing for it and who has control over it. I hope that helps.
The next question, you kind of already answered this, but it says, are there limitations on how the monies are used?
Yeah, you just want to make sure it's not for food and shelter out of a supplemental needs trust, and it's always for the benefit of the beneficiary. There's a thing called a fiduciary accounting, something we do in our tax office, because we also have a tax office that does all the taxes and all the accountings here too. We have to memorialize what everything is spent on, and that's what we send to the courts, or we have some beneficiaries and some trustees that say, please show me what it was spent on. So you asked, is there limitations? Out of a supplemental needs trust, no food, no shelter, and always for the benefit of the child. Where is this going to come to hurt you? Is if you have a first party trust and Medicaid goes, at the death of Johnny, they knock on the door and say, hey, you have money left over. You're going to say, no, I don't. They're going to say, prove to us where you spent that money. So it is always good practice to get what's called a fiduciary accounting done at the end of every year. So when Medicaid comes and knocks on the door, you can prove to them that you didn't misuse the money. Also, it's a good way to show when the trustees change, mom and dad die, and another child takes over as a trustee. It shows how that money is spent and that nothing was misused, and it gives them a roadmap of how to do it. I want to be careful of time.
The next question is, what do you do if you're in the military 2 years before retirement and have a disabled child who is 4 years old, in addition to 2 other children, ages 11 and 14?
Seek local counsel. That's a very big question. I would ask you to look up this website. If you got a pen and paper, take this website down. It's called Special Needs Alliance. Special Needs Alliance is a great resource. On our website, it's actually on there as one of our marked pages. You can go down, just click, and it takes you right there. Special Needs Alliance will give you a list of practitioners within your area that should be very knowledgeable on supplemental needs trusts and be able to answer your questions directly. But I really have to push that one off to local counsel. And just to be clear, our website is Kautz Buckley Financial, Kautz Buckley Financial. And there's a section, a tab at top that says Supplemental Needs Trust. And if you just read a little bit about down below, it has special links. And one of them is.
Okay, our next question is, what is the best way to determine how much money to put in the supplemental needs trust? We have 3 children. Putting too much in the trust would delay the remainder going to the siblings, while putting too little in the trust would not provide enough for our disabled child.
The best answer to that, and how we get to that answer, is we do a financial plan for the clients. We sit right down and get very in depth in a financial plan. We map out mom and dad's retirement, how that's going to go, and everything else. Then we understand what money is actually left to go to the child. I'll tell you, the simplest thing, or not simplest, but common thing here is you might want to think about getting a life insurance policy that's called a second to die or survivorship policy. This is not a recommendation. This is not a solicitation. This is just an example. A second to die life insurance policy or survivorship policy will say, I insure mom and dad pay the premium. But the beneficiary of that premium, of that insurance policy, is the supplemental needs trust. That way you have a guaranteed vehicle. If it's life insurance, I want to be careful using the guaranteed vehicle. You have an identified vehicle that's supposed to go directly to the trust. So any other money that's spent can be pushed on to the kids or your retirement. And the only thing you're putting at risk is the premium. That's one way to get around, to get that done, and not to jeopardize my other kids. Okay, that we see that. But first, I put together a plan to realize how much is that going to cost and what should that life insurance policy be.
Somebody asked about ABLE accounts versus the S&T trust, or the trusts, which you already answered. And then another question is, do you have a list of colleagues or trusted financial advisors you are aware of around the US, which you answered with looking at the Special Needs Alliance to get that information.
Right.
I did type that into the chat so that people can look that up. Another question is, do you recommend getting a lawyer first or a financial planner? And how do you go about it?
Lawyer first. You got to build the car before you put the gas in. I have great relationships with a couple lawyers that know that I think, as you can tell, as you go through this, we have quite a bit of experience in it. So a lot of times we meet the clients with the lawyers. We'll do our meeting together. But you might want to find the lawyer first, the planner second. That's it. The back end of that question was who should go first, but what was the other part?
The other part was how do you go about it, which I would think you would refer them back to the Special Needs Alliance.
For the attorney to the Special Needs Alliance, and then ask the attorney if they have somebody involved as a financial planner that's knowledgeable. The little plug, I guess, we're licensed in almost every state. So, you know, if you got a trustee all set, they can contact us and we can probably help you out with the financial planning end and the investment end. But again, other planners are out there, other people are out there. Make sure you have great vocabulary here, a handle on what you're talking about, so you can interview planners and get a good feeling.
And then another question is, how do you decide how much someone should get paid as a trustee? Want to pay them for their time? Can you pay someone out of the trust?
Local laws, but I'll tell you, in New York, we have a statutory rate. We have a statutory rate that says a trustee gets paid this much. But that, again, refer to your local attorney and laws. It'll be outlined. That clears questions.
I actually have a question myself, if that would
we're out of time.
I know. Snip, snip. I'll try to phrase it so it goes quickly. We have been advised by our attorney so that our will is set up with a testamentary trust that funds after, when we pass. But hearing you talk about the SSI, and I did not know that our daughter would be eligible, as we're close to retirement, and would be eligible for a part of that, which, if I do the math right, is going to put her over her $2,000 a month or $2,000 if she's getting income from that as well. So that tells me that we really should be looking at third-party trust as well. Would that be your take on that? I mean, we've done a really good job of keeping her broke. We were told that was her job.
It's funny you say that.
Sadly, that's been easy.
This is the same law and everything, and the same idea used when mom and dad go in a nursing home. Yeah, good idea to keep them broke. But to answer your question, number one, your daughter's receiving income through no fault of her own. She'll be considered in the Pickle Amendment. Okay. So I would reach out to Social Securities and make an appointment with them and sit down and explain the situation.
Okay.
And it very well may be that you're in no peril. However, if she is over-resourced, right, then you may want to think about first or third-party trust. And that gets a little more difficult because you got to realize that your daughter, the payment that she's getting from your SSI is in her Social Security number.
Right.
So it's not a third party, it's a first party. Now that goes to say, well, do I really need to spend the money for this? It's only a couple bucks, and so a little later in life, maybe I use an ABLE account. So I would first, in your situation, talk with Social Security to identify what she would be eligible for. They're not going to give you an answer till you're closer to your retirement date, but you can at least do a little research and talk to them.
All right.
And then at that point, when the money starts coming in, that's when I'd ask you to consult with your attorney and think about, do I need a first or a third party trust?
Okay. That's helpful. Yeah, it's coming like a freight train, and we didn't
know. That money is coming from her Social Security number.
Okay. Thanks for pointing that out. Appreciate it.
Any other questions? How are we doing? Ready to move on to the next guy or girl?
You've answered all our questions. Everyone in the chat and in questions has been expressing how thankful they are for all of the information that you've shared today. It's really a great presentation filled with a ton of really awesome information. Dan, we want to thank you for this. Like I said, this was really amazing, and it's a lot of really great information that our families really appreciate. So thank you. And thank you everyone who joined us today.